Our next case is State versus Stoehr, and I'm probably not saying that right, and I apologize, but everyone ready to proceed on that matter?
Yes, Your Honor.
Yes, Your Honor.
We're right about on time, but we're not expecting anyone else to be here. We have everyone we are expecting to be here.
We do.
Each party will have 15 minutes to present their argument. The appellant may reserve up to 5 minutes for rebuttal. Counsel, how long would you like to reserve?
3 minutes, Your Honor.
I will remind everyone we still have the finality issue as well as the merits in this time, and however you want to divide your time up and talk about that is up to you certainly. But you can talk about that as you will. The arguments are being recorded. When you come up, please introduce yourself, tell us who you're representing. Make sure you stay behind the podium so we can hear and see you on the recording. In this case, we do have some victim/minors, so if you're referring to them, please refer to them by their initials rather than their full name. Having said that, we've read your brief and are ready to proceed whenever you are.
Thank you, Your Honor. May it please the court, my name is Jim Saywell, and I'm here today representing a Catholic priest, Father Larry Jersick. Father Jersick is a third party to this criminal case. His only involvement is that he had private, confidential religious counseling with the alleged victim in this case. The defendant wants Father Jersick's private religious counseling notes, and the problem is that those notes are privileged as a matter of law. It was undisputed below, and the record remains clear here today, that Father Jersick engaged in religious counseling that was confidential, and he did so in his capacity as the pastor at St. Mary's in Hudson. It's further clear that the only responsive records that Father Jersick has are the records from that private, confidential religious counseling. It was therefore able to be determined as a matter of law, without an in-camera review, that the records were privileged under Ohio law. An in-camera review with no genuine dispute of law or fact is neither necessary nor proper. And that's the case for any privilege, but it's especially the case for a constitutional privilege like this one, a constitutionally based privilege.
Let's take a step back. How did it come that the the defendant was aware through discovery that the priest had some involvement? He talked to the police at some point in time?
That's correct.
And is there a statement in the file from the police saying we talked to the priest and he said X, Y, and Z?
The defendant for the first time on appeal has referred to that police statement. That's not in the record. I've actually never seen that statement. But yes, that is, I know from the appeal that there is this police statement, and that's how the defendant found out, I think, about the
Are you
Father
aware at
Jersick's
this point in
counseling.
time, it's not in the record, are you aware of what exactly the priest said to the police, your client?
I'm not aware of it, but I can take exactly what the defendant represents on appeal was said in that statement, and I still maintain that there's no factual dispute, no genuine factual dispute requiring an in-camera review. So the defendant on appeal, so this is the argument that comes too little too late. Too late we've referred to, it's not in the record, and this argument was not made below, but it's also too little anyway. Again, taking exactly what they say that there are 3 disputes, this is what they say on appeal, and none of those 3 creates a genuine dispute. So the first is that they say it's unclear as far as who Father Jersick was communicating with. But that's not unclear at all from the record here. Father Jersick has a sworn affidavit that was never challenged below, and that is crystal clear that the communications were exclusively with the victim and the victim's family. Those were in private religious counseling sessions. The second thing that the defendant says is unclear on appeal is whether those were kept confidential. But again, that sworn affidavit says whatever was told to the police is different from those private religious counseling notes, and that nothing that was disclosed in the religious counseling has been disclosed to anyone else, as is consistent with Father Jersick's typical practice and the typical practice of probably any pastor or priest, Catholic or otherwise, is that they don't disclose their private religious counseling sessions with family members. And then the third thing that the defendant alludes to, again, only on appeal, not below, but even taking what they say verbatim, is this idea that there were other people present, and that potentially creates some need to look at the records in camera. But the other people present were family members, the two parents plus the child. Again, that's clear from the affidavit, and that as a matter of law, the presence, the alleged victim is 9. The presence of his parents does not defeat even an attorney-client privilege, far less a clergy privilege.
Because he's a minor?
Well, not just because he's a minor. There's actually a case in re grand jury out of the Third Circuit that dealt with this about family adult children, but especially because he's a minor. And we cite some cases in
that a clergy case without an attorney-client? That
was a clergy case, the Third Circuit case. And very factually on point. So those were the alleged disputes that the defendant now says requires in-camera review. None of those creates a genuine dispute.
So what was actually argued by them at trial court level?
That's exactly what I was going to get to, Judge Carter. Thank you, because what was the only thing that was argued below there was no factual dispute argued. The only thing was that this statute, 2930-071, this victim's right statute, the only thing that was argued is that statute required in-camera review. If you read the statute, I read it differently, but the judge below disagreed with me. The problem now on appeal, and the reason you don't see 2930-071 featured at all in their brief, is that that's been repealed.
Do you think it applied in the first instance? Assuming it hadn't been repealed, did that statute apply?
It did apply. I think Judge Bro was correct to apply that statute because they're records concerning a victim. It's not just victims' records, it's records relating to a victim, and these records do relate to a victim.
Since that's been repealed, and I don't think that dispute has been repealed,
Pardon me?
Your view be the matter should be sent back to trial court to proper review under 29, the privilege statute.
Right, 231702. I know there's a lot of Ohio revised codes. That at a minimum, Your Honor, would be the bare minimum that I think would be proper for this court to do, would be to remand and have the question about whether there is a genuine dispute sorted out below in the trial court. But I don't think that's necessary to do that remand because it's just so clear that there is no genuine dispute. Again, the only thing in the record that bears on whether privilege applies is the subpoena, which requests religious counseling notes, and then Father Jursik's affidavit, which says the only thing I have are private, confidential religious counseling notes. And if you look to 231702C1, the clergy privilege, it applies without question. It's a cleric shall not testify concerning any information confidentially communicated to the cleric for a religious counseling purpose in the cleric's professional character. That is exactly what we have here. It would be as if you requested the emails between attorney and client giving and asking for legal advice. You don't need in-camera review to say, oh, that's privileged. And here it would be especially improper because this is a constitutionally based privilege. So
Appellee in this case indicates to me the difference between confessional communication and counsel communication in that in one, the diocese rule says that the confessionals are inviolate, cannot be disclosed to anybody entering into the circumstances. I understand what it's saying. And that the diocese says counseling notes are different because they're confidential, but they could be disclosed as required by law. And if the court ordered them to be disclosed, they're required by law.
Almost exactly, yes, Your Honor. That's a red herring in this case. We're never claiming that this was a confession. But the reason I say almost exactly yes is it's not just whenever a court orders them disclosed. The court may only order them disclosed. In other words, there's only an exception for the non-confessional religious counseling notes in narrow circumstances. And on appeal especially, those narrow circumstances are conceded to not apply here. That there is a deemed waiver by law provision when the priest is a mandatory reporter. And that's when you can never get a confession, but you can get religious counseling, private religious counseling notes when the priest is a mandatory reporter and receives information from a child. That does not.
In your view, that he's only a mandatory reporter in these cases when it is another clergy member who is the abuser?
Yes, and that's not just our view, that's also now the defendant's view on appeal. They concede that, and I can find the page for you here.
They do seem to concede that. That's your view of the statute involved, 51-421,
Yes.
that it only involved for clergy, only that narrow exception. Otherwise, if some child goes in and says, I was abused by my father, grandfather, brother, sister, neighbor, no obligation on the clergy to tell anybody about it at all, if it's for religious.
Not a mandatory reporter.
Not a mandatory.
And the exception is if that person with your list, the brother, the sister, etc., if that person is without any connection to the church, meaning they're not, it's not just other priests, it's also people.
Right, it's a little more broad than priest, but it could be any.
But yes, that they are not a mandatory reporter, and that I think is now agreed on appeal, and it is also clear from the yet another statute that bears on this case as you read it out, .421.
Did the trial court grant the motion to quash or deny the motion to quash in this case?
The trial court, I guess, so this now gets the jurisdiction, which let me go right there. So the trial court denied our request, which was to grant the motion to quash. The trial court.
Well, it may be in practice. I read the order never saying deny the motion to quash. I read it saying, okay, I've met this statute. The next one, this statute tells me to do an in-camera review and balance everything, and then I'll tell you what's going to happen, I suppose. It never really says I'm quashing or not, to me.
I read it the same way. So the question is whether it's a final order. We agree that, as the magistrate of this court said, and as all the parties have said, we agree that typically an order requiring in-camera review is not a final order. But it is a final order when it affects a substantial right, and this is the only time to raise the argument. And that's exactly what this does. Judge Carr's opinion, Hudson against Harger, goes through these two factors. It's also in yet another statute that bears on this case, 2505.02. B1 and B4 are both relevant here. Affects a substantial right. Father Jursik's argument is that this in fact violates the Constitution to require in-camera review when there's no genuine dispute as to
About a minute of your time left initially.
Thank you, Your Honor. And I'll wrap up with talking about why it's a final order. So does it affect a substantial right? It's hard to imagine it affecting more of a substantial right. And then can it be delayed? That's the other question. Can review be delayed until, for example, if Judge below disagrees and orders disclosure to the public? It would be too late, because what we're arguing is that the in-camera review itself is the thing that is improper. And once Father Jursik is compelled to disclose those in camera, that already eviscerates our argument and moots this appeal. So this is a final order, as I would add, and maybe in conclusion, the Supreme Court of the United States held in United States versus Nixon, which the defendant relies on a lot for the merits discussion, but they don't rely on it for the preceding discussion, which is that it is a final order appealable prior to in-camera review for this certain narrow subset of categories that we fall into. And with that, I'll save the remainder of my balance, the time for rebuttal.
Thank you.
Thank you.
Thank you, Your Honors, and may it please the court. Attorney Andrew Stein on behalf of defendant Belly Jeremiah Stoehr. This case is about two issues: whether the trial court can properly follow the law according to the statute and according to the Supreme Court in Potts, and whether or not a privilege can be used to shield the third party from that order for in-camera review. I'd first like to address the jurisdiction issue, since we ended on that. I think that Daher is direct on this issue as far as whether or not it's a final appealable order, because it's not. The court does not grant or deny a provisional remedy in this case. In this case, the entire motion to quash, as you guys discussed, the motion to quash was not entirely denied. The court never did order disclosure of any records or
But
denied
it would be disclosed. It would be disclosed to the judicial officer.
Well, that might be true, but any of these other courts cases that are discussing in-camera review, attorney privilege, grand jury discussions, medical records, all of those cases, especially as discussed
Don't
in.
involve religious freedom.
Well, sure, they don't resolve in religious freedom, so that's where the substantial right comes in. But those cases discussing whether the substantial right is affected and whether it can be resolved, those are generally relying on this collateral order doctrine, which is a federal doctrine that hasn't been approved and adopted by the Ohio Supreme Court. So, and I think that, talking about whether or not it's being disclosed to the court is a violation of any sort of rights. Well, we're expected to rely on judges to maintain the confidentialities and privileges of the parties, right?
But what about these particular records, documents, communications, whatever you want to call them, would make them non-privileged?
So the opposing counsel discussed one of the exceptions, the mandatory reporting exception, but he did not discuss two other exceptions. Whether there's a direct waiver of the other party, in that case, the clergy may testify, and in another case, if the penitent or the other person is voluntarily testifying at the trial court, then the clergy member may be compelled to
But none
testify.
of those things happen.
None of those things have happened yet, which is
At this time that folks have been disclosed as witnesses in this case, we are not to that point yet in discovery.
Well, we are not in that point. Obviously, we've received the police reports, the general discovery documents. I believe there may be a witness list listing the parents. If not, they're riddled in they're all over the discovery, and they've made statements to the police. So it'd be
The record at this
expectation.
point doesn't include a witness list that we can look at and say, these folks are listed as witnesses, either the priest in this case or these family members are listed as witnesses.
As far as the trial record, the court record goes, it's possible it's not, but we certainly received discovery disclosures listing those witnesses and identifying those witnesses throughout the police reports.
Counsel, if 293071, which doesn't exist now,
Correct, that's correct.
if it hadn't existed at the time of all these proceedings, what basis would you have had in order to get a victim's counseling records?
So the basis would be in POTS, right? The in re subpoena divistivo upon attorney POTS. And in that case, it explicitly talks about if there's a motion to quash and there's a question about whether or not there's a privilege, then in those cases, if the court finds that the proponent of the subpoena meets those four requirements, then the court shall
And
order
what
an
was
exam
POTS
review.
about?
Excuse me?
What was POTS about?
POTS is about attorney-client privilege.
Right.
Another
So here
statutory
you're talking
privilege.
about a criminal case involving a victim that is alleged to have been raped, and you're trying to get the counseling records, whether it's a psychologist, a priest, or whoever.
That's correct. So under Criminal Rule 17, which allows for subpoenas, such a subpoena could be filed to get records of a counseling from a therapist, counseling with a nurse, or any sort of therapy records. Those sorts of things you would theoretically be entitled to get, barring any privilege.
That's the whole point, barring privilege.
Barring any privilege, and the court is given the ability to balance those rights and privileges of the victims based on Marcy's law and based on other.
Okay, so then we're back to 293071.
So
Did
we
you
are back.
file the motion for the records solely under 293071?
I believe we filed the subpoena under Rule 17, and then the opposing counsel, Father Jurczyk, filed his motion to quash, arguing that it was privileged, right? He did not argue he argued that it was unreasonable or oppressive because of his privilege, not that we would fail to meet the requirements under POTS or under the statute, right? So we replied saying, no, the statute applies and it demands that the court hold a hearing to determine whether the POTS standards and the statutory standards are met. And then based on POTS and the statute, the court is required to hold an in-camera review to determine whether
The
privilege.
trial court, in this case, did you serve the victim with a request for the information?
We had, in accordance with 2930.071, they were actually provided to the victim, the victim's attorney, if they have one, and the prosecuting attorney. In this case, we requested that we asked the prosecuting attorney if they would serve it on our behalf to the victim. It's our understanding that that happened. So we complied with at least that.
And the victim did not. We have the father's, the priest here, motion to quash, but nothing was filed by the victim requesting.
That's correct. There was no motion to quash filed by the victim or his parents. Actually, during the trial court hearing, there was a question about whether or not the parents or the victim would waive their rights and would provide a written waiver.
Is that in the record?
It's in the trial transcript, I believe.
Hearing transcript.
In the hearing transcript, excuse me. I can get you the exact
That's all right,
line.
that's all right. We have it. If it's in the record, it's in the record.
The trial court, in this case, applied the statute since it's been repealed.
That's correct.
How can we then review the trial court decision, which is based upon a statute that's been repealed, and everyone said, well, you can't use that anymore?
Well, our position would be that the statute is codifying the rules set forth in Potts by the Ohio Supreme Court, which doesn't limit itself to any specific type of privilege. It doesn't limit itself to any type of proceeding other than the fact that if a subpoena has been filed and a motion to quash has been filed, then it must review on those four elements, determine whether those are met, and then it explicitly says that the trial court shall conduct an in-camera inspection of the documents in question before ruling on any claims of privilege. Obviously, the court has never gotten to the point of ruling on that privilege.
After Potts and before this statute was adopted, 290307, whatever it is, were there any cases applying Potts to questions of clergy privilege that you recall?
I do not recall any questions about clergy privilege regarding Potts. However, I will note that this court has utilized in-camera review to determine whether privilege applies in a clergy case. That case was McFarland. I believe it's certainly cited throughout our briefs because this court has explicitly used and without question and reviewed documents that were claimed to be privileged under the clergy privilege statute and determined document by document, reviewed everything that was provided, whether the documents were confidentially communicated, whether they were for the purposes of religious counseling and those sorts of things. Talking about this idea that whether or not there's any dispute about the privilege at all, I do think that there are questions about whether these are privileged, even based on just the general questions. Primarily, one, whether they're confidentially communicated. There was some discussion within the police report and obviously in the briefs about whether or not the parents were there and whether or not the alleged victim in this manner made any statements to the priest about the alleged incidents. I'll note in the affidavit itself, which generally lacks a lot of context or any content about when and how these disclosures, these conversations occurred, other than stating it's just religious counseling. Well, we know now that it's not confession. It was this religious counseling, and he says that he just basically says, and this is a quote, I possess no records or related notes that would fall within this request, the subpoena request, and are not related to religious counseling that I provide. So he's blanket stating that these are privileged without providing any context for how
What
they're
context does he have to provide? That on such and such date?
I think that would certainly be helpful. Obviously, it's his burden to prove that these documents are privileged. It's not our burden to prove that they're privileged. Our burden started in the trial court at meeting those four documents. Of course, our position was that the court was required to find those 4 points, and then at that point was required to hold an in-camera review. So we never addressed generally whether those issues of whether these documents were privileged were never decided by the trial court, were never addressed by the trial court.
When the statute itself make a rebuttable presumption that if a priest or an attorney or whoever says this is attorney-client, or especially in the context of religious freedom, that they say that it's that these are privileged and the only communications I have is in my role as counseling them in their faith, wouldn't that then shift to the person that's asking it to find an exception under the statute?
Well, it's certainly possible that I would posit that burden never shifted because the court never made the determination under the statute or under Potts about whether that privilege existed. And also, I would note that the court still has to review these documents to determine, and it's not a matter of law that if there's other people present, that it still maintains the privilege. The In re grand jury case, I believe, comments that the court should still make a determination based on the contexts and all those sorts of things about whether or not the appearance or the presence of other individuals.
Except here you have family members. No one's disagreeing about that, right?
We're not disagreeing that they're family members or that, but it's certainly possible that the court may determine that those communications were not privileged. The other question, of course, is whether there's any express consent. We know that while it's not as the opposing counsel noted, that it's not in the trial court record, but we did cite these in our original opposing motion in opposition to the motion to quash, that the Father Jurisic did go to the police. And the question that the trial court, one of the questions
Is that in the record?
Excuse me?
Is that in the record?
Is the police report in the
Yes.
record? No, the police report is not in the record. Again, our position at that point was that the privilege was not, the question about privilege was not at that stage. It was whether or not we've met those four points. And certainly, if this court were to remand it, or if this court would request that document, we could certainly file a motion to open the record or to amend the record to include that written statement so that the court can review it.
The record in this case is there was not evidence taken, as I recall. It was a oral argument type hearing with the trial court judge.
That's correct. There was evidence. Of course, there's the affidavit, and then, but other than that, the opposing counsel and Father Jurisic isn't disputing that we haven't met those requirements of Potts and the requirements of the statute. Is for things that there wasn't any evidence to support that. The court, he doesn't dispute that the court properly found that those four elements are met. His problem is further on down the line, is whether or not the in-camera review order is proper, and whether or not that should have been ordered at that time.
Do you agree that the clergy member is only a mandatory reporter if it's a member of the clergy or a church official or someone associated with the church that is the alleged abuser?
I believe at this point in time, yes, that is our position, that while he was not a mandatory reporter, he acted as if he was a mandatory reporter. And that, again, raises the question of whether or not there was any voluntary waiver or a waiver by the priest himself by disclosing those communications. And that raises the question of whether or not these are confidential at all.
Or a little less than a minute left, I'm sorry.
And then the question becomes, again, you discussed whether if this was confession or whether this was religious counseling. And under the canon law of the church, only confession is violable, or disclosure of confession is violable, and the disclosure of other sorts of conversations is not violable, and that they may be disclosed.
Is this court in a position to determine canon law?
I think the priest is certainly asking the court to determine whether or not his communications were privileged.
But he's only doing it under the statute.
The statute discusses questions whether or not these discussions were whether or not these discussions fall under the sacred trust. The sacred trust is whether or not, under the doctrine or canon law of the church, the disclosure would be a violation of that question. So the court would be in a position that we have to answer that question because the statute directs it to. And as far as whether if these witnesses testify, that's certainly something that should be resolved now by the trial court, or at least after this appeal by the trial court, to determine whether or not, to avoid any sort of delay or any sort of delays during the trial. Say, if those witnesses do end up voluntarily testifying about these conversations, well then, theoretically, we would be able to file a motion to request that Father Jurisic be compelled to testify because they have now disclosed those conversations. And so the court, especially in the statute, in Nixon and in Potts, it points to this idea of needing the records prior to trial to avoid any undue delay during the trial proceedings.
Well, it's easy to move past answering Judge Carr's question. You're out of time. You
Apologize.
conclude.
I apologize.
That's okay.
So for the reasons discussed today, in our final briefs, I ask that this court hold that it does not have jurisdiction for the lack of a final appealable order, and alternative overrule the appellant's assignment of error and remand this case to the trial court with an order directing him to turn over those records to the court for an in-camera review. Thank you.
You have basically your 3 minutes, counsel.
Thank you, Your Honor. 3 points on rebuttal. The first is on jurisdiction, and I'll stay quick here. Stoehr is distinguishable factually. It involved grand jury records that the court had already overseen and no constitutional arguments. There was no argument there, most importantly, that the in-camera review itself affects a substantial right, so it's distinguishable. And as an alternative path to a final order, we have Hudson against Harper from this court, from Judge Carr, which recognized that this narrow collateral order doctrine also codified in 2505.02b1, where it affects a substantial right and where it's now or never. And that's the argument here, it's now or never. So that's on jurisdiction. We have a final order making the merits arguments proper. I hear 2 arguments from the other side. The first one is POTS. And they're reading POTS in a way that it says, no matter what, whenever privilege is invoked, in-camera review is mandatory. That is reading POTS out of context. Not only was POTS a attorney-client and not clergy privilege, so not only do we have those problems that Judge Carr identified, POTS meant that you must order in-camera review before disclosing to the public. It's a final fail-safe. It's not a way of undermining a privilege, it's a way of aiding the privilege. And we have a litany of cases that prove that our reading of POTS is correct. It's not whenever privilege is invoked, you must have in-camera review. Stoehr versus Summa Health, which came out of this court into the Supreme Court. That court and this court discussed that you can do exactly what we did. Produce an affidavit, and if that affidavit is clear, there's no genuine dispute that a privilege applies, there is no in-camera review. Zolan, Geraci, Reynolds, Ellis, grand jury, all of those cases cited in our briefs are cases in which there is
How do you dispute that? So the priest comes forward and says, nope, nothing here for you to see, anybody, good luck. They can't see it, so how do they even know to contest that this is in fact covered by the privilege or not? What position does that leave them into other than all just saying, well, of course, every member of the clergy, the honest person, would never say anything inappropriate?
It's an extremely important question, and the answer is that they have many ways that are recognized that probably happen throughout the state, day in and day out, of defeating or disputing and creating a genuine dispute as to what an affidavit says. One obvious way is if they have this police statement, they could have put that into the record. They didn't. Another
There's
thing.
no dispute that he went and talked to police.
Right, but that fact alone doesn't.
And that, to some extent, could be a waiver of the privilege. If he goes and talks to other people, would that be a waiver of the privilege?
Not unless he's talking to the other people about what he learned in religious counseling, and he didn't. If he had disclosed his private notes to the police, then yes, that's a waiver. But that's not what he did.
If he went there and didn't disclose the notes, but said, a victim told me that they were abused on this day by this person, would that be a waiver?
It does not waive everything else that's in the records, right? So he swore that the records do not contain.
Would that in-camera review then come forward to say, okay, he told the police X, you could see these things he told the police, but the rest of this we're going to cross out and say, you don't get to see all of that, was about the religious counseling portion.
That would be what he could have done, but we again dispute that, he didn't do that. But also that wouldn't work here because of the nature of how even the defendant represents what was said in that police report, which again, I've never even seen. But that even basing on what they said, it does not actually create a dispute with what matters here, which is, do you have confidential religious counseling in your capacity as priest? And that's all the notes he has. Is relating to that, nothing of which he disclosed to the police, the content of those or the actual notes themselves.
And I know that answered my question. I thank you for that. You're over time. If you briefly conclude, please.
Yes, we ask that the court either remand at a minimum with the statute now repealed, or it's not necessary to remand because quashal is the only appropriate remedy on remand. so the court can order quashal. Thank you, Your Honors.
Thank you, and thank you both for your presentation this morning on behalf of the court. The court will take the matter under advisement, release a decision in due course. When that decision made, it will be mailed to you by the clerk of court and also available on the High Supreme Court website. And this being our last case of the day, with that, the court now adjourned until